Okay, hi everyone. This is Eric from HR Simple, and I want to welcome you to today's ADA and FMLA webinar. Our speakers are Frank Day and Robbin Hutton from the FordHarrison, Memphis, Tennessee office. Frank is the author of Hiring, Firing, and Discipline for Employers on HRSimple.com. I also wanted to mention Nancy Holt, who's from the FordHarrison, Washington, D.C. office. She offers the ADA FMLA guide. Stick around for a deal on these publications at the end of the presentation. Today's presentation will last approximately 60 minutes with some extra time for Q&A at the end. HRSimple.com is an HRCI approved provider and a SHRM preferred provider. At the end of this webinar, we'll give you codes for both certifications. We encourage you to enter your questions in the chat box and we'll address them when we can. A recording and slides will be emailed to all registered attendees after this presentation. We're also posting all of our webinars at youtube.com/HRSimple. And now just to give you a little background on our speakers today, we have Robin W. Hutton, who has over 15 years of experience in a variety of practices with 11 years exclusively devoted to employment and labor matters. She has successfully litigated numerous employment matters in both state and federal courts and achieved favorable results before numerous administrative boards and agencies in numerous states. Robbin works with clients in developing and implementing employment policies, as well as training on the major areas of employment, harassment, discrimination, FMLA, FLSA, immigration issues, union issues, and ADA, as well as conducted many work-related investigations for clients, as well as HR audits for employers. Our other speaker is Frank Day. Frank Day devotes his practice to helping clients accomplish business objectives through employment law litigation and counseling. Frank has successfully represented national retailers, healthcare providers, and various other public and private employers in matters arising under Title VII, the ADA, FMLA, ADEA, USERRA, and various other federal and state statutes. He has extensive litigation experience in many different forums, and he has helped many clients prevail on summary judgment and at a trial. Frank frequently serves as a faculty member at employment law seminars, and he has published articles in the ABA Employment Law Newsletter, the Tennessee Bar Journal, and the University of Memphis Law Review. I want to thank both of our speakers for coming on today. I want to thank everybody for tuning in. I'm going to just go ahead and turn it over to Frank if he's ready.
Yes, well, thank you, Eric. We definitely appreciate the introduction. As Eric said, I'm Frank Day. I'm an attorney in the Memphis office of FordHarrison, and Robbin Hutton will also be a presenter with me today.
Good afternoon.
So, the title of our program is Anyone Working Anymore? Problems with Managing Leaves of Absences. And we selected this topic because a lot of our clients, we're talking some of the largest multinational corporations down to small business owners who have one location for a pizza shop. We represent businesses very large and small, and one thing we noticed that is a constant problem for businesses, both large and small, is managing leaves of absence. And this issue is one that we deal with often, but the reason we wanted to talk to you about it today was because the problems that people experience in handling the legal aspects of leave create business problems that reduce productivity, result in wasted time, and a range of other issues that we feel like can be prevented on the front end by knowledge and good policy. So without any more delay, we'll go ahead and get into the program itself. As most of you probably know, the purpose of the ADA is to prohibit discrimination against persons who have a qualifying disability. And the law, to further that goal, also requires employers to provide reasonable accommodations. We're going to discuss these topics in more detail today, but just as an introduction, those are the main purposes. Now, the FMLA, on the other hand, is a statute that requires employers to provide a specific amount of leave for individuals who fall within certain categories, such as individuals who have a serious health condition, or people who have, for the birth of a child, and a number of other situations, military leave, etc., as an introduction. So the ADA and the FMLA are two topics that, when possible, it's great to address together because the spheres of influence overlap. On the one hand, you have the ADA, which requires reasonable accommodations, and in many situations, leave and allowing an employee to be off from work can qualify as a reasonable accommodation, whereas the FMLA provides for and requires you to provide leave to certain qualifying employees. So an employee who is qualified under the FMLA for leave may also be entitled to leave under the ADA, and vice versa. So an employee who qualifies for leave under the ADA may also qualify for FMLA leave. So, okay, thank you, Robbin. So basically what we have here is a visual representation of the interaction between the ADA and FMLA leave and other laws. I think one thing you'll notice is this is a visual representation of the complexity that arises when it comes to leave-related issues. All of the different circles and spheres included here is another area of law that you have to account for when it comes to leaves of absences. Now, we're not going to talk about each of these individually right now, but one thing I do want to point out is when it comes to your policies are the starting point for you to take the chaos that can be managing leave and make it manageable. And so basically when it comes to your policies, they should be tailored to your business, and they also need to be user-friendly. And if they are both of those things, you can really start to have a framework for dealing with and addressing each of these different sources of law that can provide for and require you to grant leave to certain employees. So who is eligible for leave under the ADA? Well, first of all, the ADA applies only to companies that have 15 or more employees who are employed for 20 weeks in a current or preceding calendar year. So just generally we'll say it applies to employers who have 15 or more employees. The ADA, the FMLA on the other hand, applies to employers who have 50 or more employees. So we have different thresholds, but one thing you need to account for is that there are state laws that can set lower thresholds that provide the same or greater coverage. That being said, we have the ADA. It covers people with qualified disabilities and who can perform the essential functions of a job with or without accommodation. And the FMLA, as you see on the slide, it applies to certain employers who meet certain requirements when employees who meet certain requirements, and also provides 12 weeks of leave for those who do.
And then the next thing that we're going to look at would be what conditions are going to be covered. And as we previously mentioned, under FMLA, there are a number of different categories where the employee may be able to take FMLA. Today, our focus is going to be solely on the serious health condition of the employee and in looking at that and comparing it to the ADA. Under the ADA, what's covered? You have to look at the meaning of disability. It's an impairment that substantially limits one or more of the major life activities. You have a record of a disability or being regarded as disabled. And we all know that the ADA has been amended, and from that it has been expanded. And things that we used to not consider may now be possibly considered a disability. And if you're looking at the definition of it, it comes back to whether, again, it substantially limits that major life activity. Also, it could be possibly complications from pregnancy. And it can also be major bodily functions and others. And they don't look at the mitigating measures anymore. And we used to do that a long time ago. We no longer do that. And then also we look to see whether that impairment is episodic or in remission to see whether that's going to be a disability as well. And what's interesting in this is back in the day, we used to say a temporary condition was not going to be a disability. Well, under certain circumstances, a temporary condition can be, meaning if it's such a severe break to a leg or a foot, that there's a lot of pain involved, there's a lot of treatment involved, that may elevate the situation to one where it may become a disability at that point in time. And I just recently had a case dealing with such a situation where the individual had actually broken her foot. It was a very bad break. She ended up in the hospital, had to have multiple surgeries. The pain, she's on a lot of pain meds, a lot of rehabilitation. In that situation, the employer's like, do we have to accommodate this? And in looking at it, we believe that she came within that, and it probably did exceed being something that would consider being a disability. And so when you start looking at the serious health condition, you have to look to see, have they been out to 3+ consecutive calendar days? Do they have that continuing treatment by a healthcare provider? And then you also need some type of period of incapacity that's long-term or permanent. And then you've got to have the multiple treatments. So that's how you get to the serious health condition. And usually what I always say when you're looking at that, don't look at what someone's telling you, I've got a cold, I've got a flu. Look at the actual time period that they're out. Are they going back to the doctor? Look at the specifics before you make that determination of, oh no, this can't be an FMLA covered event. You need to look at it, make sure it fits within that, and you might be surprised at some of the situations that do really fall within that. And then, of course, some of the other FMLA areas that you would look at would be the exigency leave for military and also the serviceman leave. And so you would look at those again to see if they qualify under the FMLA. But when you start looking at the ADA versus the FMLA serious health conditions, a lot of those serious health conditions do not qualify as ADA disabilities. And that's where you've got some of the short-term inpatient hospitalization, things of that nature, and where you've got just a regular break, something that's going to be over very quickly. That's not going to elevate to an ADA situation, but it very well could be an FMLA situation. And you need, again, look to see how long are they out, is there continuing treatment, what's going on with it. And so you need just to look and see and make a, it's going to be a case-by-case analysis that you're going to make throughout when you're looking to see if it's an ADA versus an FMLA situation. And as I mentioned earlier, when the ADA was amended, it really did expand what was going to be considered a disability. And at one time, the recommendation was, you don't ask. You let the employees come to you. Now, because of the expansion and some of the other requirements that we're required to adhere to, we can no longer take that approach always. And in looking at these, it talks about what has been broadened. It talks about the major life activities. It also expands the substantially limits, also lists the impairments. Before, we were always waiting for court interpretation. Now, when this came out, it actually gave us a listing of what would be considered within this. And if you read through this as to what actually includes the major bodily functions, and these are the things that were actually included in those regulations when they came out, it covers caring for oneself, performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, and the list goes on and on. Much like when you get down to the functions of the immune system, special sense organs, and skin. If you read through this, there's not very much left off of this. And if you do look at it very closely, what is missing is wearing eyeglasses, believe it or not. Everything else that can possibly be covered has been covered, but they did not cover that one when they were expanding it. So that's about the only thing that I can tell you for sure that's not going to be a disability in this situation. And this list that I've given is, it's not exhaustive. There may be other things that are going to be covered by this. Just keep in mind that it's very broad, and it can very easily rise to that level of being a disability. And here's a listing of some of the examples that the regulations gave that would virtually always substantially limit a major life activity. And so as you look through that, that covers almost anything. And when you look at this list and know that these could possibly rise to the level of an ADA issue, you can see very easily how you're going to have that overlap from your FMLA transitioning into some possible ADA issues as well. And that only comes into play after your FMLA has been exhausted, if they're required to take, a continuous leave of absence, or if they're taking the intermittent and they exhaust it. But separate and apart from that, you may also have FMLA in place, and they may still be seeking ADA accommodation, which we're going to address a little bit more in detail. But then the question becomes, can these episodic or conditions that are in remission be considered disabilities? Well, you betcha they can. And this has also changed somewhat with the broadening of the ADA when it was amended. And a prime example of that is cancer. At one time, if you had cancer, you went into treatment, then you went into remission, then you no longer had a disability that was recognized. Well, that's no longer the case now. It will always be that if you've got some of these conditions that are episodic or in remission, that they're probably going to be considered a disability by virtue of the EEOC regulations, and you should always take that into account when you're trying to determine, do I have to make this accommodation? Is it really an ADA issue? And we're going to move now into the employee entitlements.
Okay, so when it comes to employee entitlements under the ADA, which prohibits discrimination, it prevents the employer from discriminating on the basis of any of the terms of employment on account of the disability or an employee's association with someone who does have a disability. And of course, it requires the reasonable accommodation. We're going to get to that in a little bit. But the FMLA also provides freedom from discrimination for taking qualified leave. So you can't take any steps and interfere with someone's right to take qualified leave under the FMLA, or you will face liability. As noted, the FMLA provides up to 12 weeks of leave in any 12-month period. Now, that period of time is defined by the employer. So most of the time, I recommend that employers use a rolling 12-month period. It just gives the employer more options, but you could use the calendar year. But it's up to you to define which period, how you want to measure when that 12-month period actually begins. And the FMLA also provides up to 26 weeks per year when it's military-related leave. That's separate from what we're dealing with. For the most part, you're going to be dealing with FMLA leave that relates to a serious health condition. But moving on to reasonable accommodation. Now, under the ADA, what qualifies as a reasonable accommodation depends on the facts and circumstances that exist. So really, as the law defines it, anything could potentially be a reasonable accommodation under the circumstances. But at the same time, what might be reasonable in one case might not be in another. So this slide provides just a few examples of what can qualify as a reasonable accommodation. Obviously, today we're talking about leave. Leave can be a reasonable accommodation. Lighter modified duty, modified workstations. There's a number of different things that can qualify as a reasonable accommodation. But the law does not impose an unlimited burden on an employee to offer, I should say, accommodations to persons with disability. And the limits are really drawn when it comes to, if it's going to impose an undue hardship on your business, then it's not required that you provide the accommodation. For example, let's say we have an employee who's on a weekend is involved in an accident and loses his or her vision. And his job requires them to read significant materials for his job. He comes back to work and he asks the employer to hire someone just to read to him. Now the question is, well, should we have to hire an entirely new person and a new employee just to read to this injured employee with a disability? And the question is, well, maybe you do, maybe you don't. You can't simply say, well, this costs too much. That's insufficient. In this context, if it ended up in court, you would actually have to present objective evidence to show that the burden on your business would be great. And so one way you can go about that is by showing the cost versus the benefit, and that is an analysis. A cost-benefit analysis is and can be proper, but just saying it costs too much is subjective and it's not sufficient. Now, the length of leave that you're provided under these laws is different. The ADA only requires a reasonable accommodation, so there's no specific requirement for how long an employee can stay off from work. The FMLA, however, does provide for 12 weeks of leave during the 12-month period as we defined.
And that's usually the hardest thing for employers is on the ADA, how long is too long? And that's the question that I hear the most. And the courts have recognized that any time that you can give unpaid time off as a reasonable accommodation, it would always be appropriate. But it is very hard for the employer to say, but when do I call this? And generally you're going to have to look at the needs of your business, come up with something that you're going to implement, that you're going to use across the company as to how long are we going to do this, and still follow the steps and don't say, well, we're only going to give them 30 days post-FMLA, and then we're done, and then you send the letter terminating. You've got to be a little bit more proactive than that. You know, can you define the 30 days? If that's what you're trying to do, you can. I would suggest if you do that, you follow back up with a letter to the employee saying, your time period has exhausted. Could you reach out to us, let us know what your intent is to return to work, so that once again you're engaging in that dialogue to find out if we can give them an additional 2 or 3 days before we get them back to work. But at some point, you got to call it. You've got to say, this is where we're going to draw the line on this. But then keep in mind, it's always going to be a case-by-case analysis, which is totally contradictory to what I just said. But you have to keep in mind, you can call it, but you also have to think of it on a case-by-case analysis, and it will vary from each and every one.
So is intermittent leave available? Well, part-time modified work schedules can be a reasonable accommodation. Now, the other thing, though, under the ADA is whether or not intermittent leave is a reasonable accommodation. So you still have to go through the reasonable accommodation analysis. Now, where things get really complicated is when leave is unpredictable and sporadic, meaning you don't have any idea of exactly when an employee will not be showing up for work. Now, in this situation, the employee may be entitled to leave under the ADA as a reasonable accommodation, but it's less likely. But the FMLA is not limited to providing protection when the employee is just going to miss consecutive days. So an employee who's going to miss work at times that are unpredictable, for example, with a unpredicted flare-up, the employer is still obligated to provide FMLA leave for those attendance issues. This becomes a very complicated issue. It's sometimes very difficult for employers to address. And I believe you just dealt with that recently, didn't you, Robbin?
Yes, and the best way to deal when you've got these intermittent issues that come up, and we always have them with employees, and I've got a situation where an individual has an intermittent leave for her child who has asthma, and the leave is for 1 to 2 days every 3 to 4 months. Well, guess what happened at spring break? She took Thursday, Friday, Monday, and Tuesday of the next week. Well, her FMLA was for that intermittent leave, but she called in, followed the policy. You can hold them to the call-in procedures, that she called off based upon her intermittent leave for the asthma condition that her daughter has. Well, at that point, she had exceeded the scope and duration of her FMLA certification. She had done this in the past, but not on 4 consecutive days of work. And so the best way the employer can manage this is to then recertify the individual, because she did exceed the scope and duration. She has exceeded it before. And so at that time they asked that she recertify so that they could get a better understanding of exactly what we need so that we can plan for our workforce. The problem that you run with that, but I'm a big believer that recertifications, when they're exceeding scope and duration, is a very good way to control and manage a lot of this intermittent leave. The risk you run, and I see it a lot, is friendly doctors. I couldn't find a friendly doctor if I had to. Employees seem to know where they are, and what happens? They go back to that doctor, who then gives them more time that puts them off, but at least you've got a more defined, frequency and scope. It also sends a message to the other employees who are also watching, seeing what's going on with these individuals. And when they know the employer is, keeping track, they're monitoring this and enforcing it, then I think it also serves as a deterrence on it. So always keep in mind that you can use those recertifications to help control some of this intermittent leave.
Now, when we're talking about intermittent leave and we're talking about whether attendance is essential, the FMLA provides for one analysis, but the ADA is separate and distinct. Now, the EEOC manages ADA leave, and it's their position that whether or not an employee can, attendance, whether or not they can attend is not essential. What matters is when they are present at work, whether they're able to do the job. So the EEOC takes the position that they don't actually have to be able to always attend in order for them to qualify to perform the essential functions of their job. Now, generally, courts don't take such a broad view of what qualifies as a reasonable accommodation. But one location where we need to start this is, what does your job description say? I'm sure you all have job descriptions that are written and perfect for every position that you have available for your employees. But when it comes to whether or not something's a reasonable accommodation, the question is, well, let's start by looking at the job description. Does your job description say that attendance is necessary and important to the job? If it doesn't, and you end up in court over a dispute about whether or not attendance is essential and whether or not you can, that should have been offered flexible attendance as a reasonable accommodation, you need to make sure that that's in your job descriptions. The same holds true for punctuality. Important to the job, make sure it's in the job description. That'll establish a base point for you if you end up in litigation. Now, how long is too long? The FMLA leave ends even with a disability that persists, but additional accommodations may be required by the ADA. Now, there are limits, though. A reasonable accommodation wouldn't necessarily mean keeping a job space open for a very long period of time, for example, exceeding more than a year. But it's not something that, well, the Sixth Circuit has held that more than a year may not be required, but it would be case specific. Other courts have said only reasonable to hold open a job when they're able to return in the near future. But then again, the terms in the near future is not defined. And so this is not something where any lawyer can provide you a hard and fast rule that says we only have to keep this position open for X amount of time. Now, no-fault attendance policies can simplify the life of employers because you can say, okay, you have X number of absences and discipline continues to become more harsh as they accumulate more points as they miss more and more work. You need to be very careful to ensure that any time somebody is missing work under FMLA leave or because of the ADA accommodation, that you're not adding points to the employee under a no-fault attendance policy and that they're being disciplined for missing work, or you will lose when there's a lawsuit filed against you. And the consequences of that can be significant. So if you have a no-fault attendance policy, please pay very close attention to any of these issues because you cannot have points added to the employee for those purposes. Employees who have indefinite restrictions that do not allow them to perform the essential functions of a position, they are not entitled to, if somebody's not going to be able to perform the essential functions of the job, they're not going to be entitled to an accommodation. However, if they only have a temporary disability that will be resolved, it might be reasonable for you to hold the job open. Once again, we're talking about fact-specific inquiries that will vary depending on the specific circumstances.
And probably the only definitive that we will give you out of this entire presentation is if you get a medical release back from a doctor that says Bob needs to be out indefinitely, that's when you know that you don't have to accommodate that because an indefinite leave of absence is not considered a reasonable leave. And so if you get anything along those lines, that's a bright line for you when you have a doctor that says an indefinite leave. And that's probably the only bright line that you can walk away with today.
So a question that comes up in this context is, do you have to offer light-duty work or accommodate restricted duties? And the answer is easy under the FMLA. Under the FMLA, it only provides for leave. It does not require that you make any accommodations or that you offer any light duty. The same is not true of the ADA, which again just comes back to whether or not it's reasonable. Now, we had a very significant decision in Young versus United Parcel Service. This case addressed the Pregnancy Discrimination Act, its interactions with the prohibition on discrimination on the basis of sex under Title VII, and also addressed the prior version of the Americans with Disabilities Act. I say prior version because the amendment had not yet gone into effect at the time her claim accrued. There's no way for us today to address the details of this case, to provide you with a detailed analysis of this case. It's just beyond the scope of what we're addressing here today. That being said, there are some points that we can provide you that will provide a good framework for how you evaluate issues, especially when it comes to pregnancy. And that is, under the ADA as it's amended, it's very possible that someone who is pregnant will qualify as someone with a disability. And so we had hoped that, regardless of how the case was decided, that the Supreme Court would provide some specific guidance to employers on how to go about addressing issues that relate to pregnancy when an accommodation is required, but there really was no specific, they didn't really make a holding that would give us a lot of clarification. Instead, they just created a whole new method by which courts will determine whether or not an employer has infringed upon the rights of an employee who is pregnant. Now, the continuation of the discussion of Young is that the question of whether or not it's covered under the current version of the ADA, which is it a serious health condition? Well, if there's pregnancy-related medical complications, then yes, then it will definitely qualify as a serious health condition and likely a disability. There is still somewhat of a debate about whether or not a healthy pregnancy qualifies as a disability, but we believe that it's the safer course of action to go ahead and treat it as a disability under the ADA, because it is under the ADAAA, the 2008 amendments, the expanded definition and the expanded scope of the coverage would seem to embrace that. So if you have a pregnant employee who comes and says, has a problem with performing their job duties or raises any issues there, seeks an accommodation, you do need to engage in an interactive process and determine what is reasonable under the ADA.
Another decision that came down last year in the Sixth Circuit that had a real impact on employers was the telecommuting as a reasonable accommodation. And this case was EEOC versus Ford Motor Company. And it involved an individual who was employed by Ford as a steel resale buyer. And Ford asserted that the resale buyers act as intermediaries, and they're in between the steel suppliers and the part manufacturers, and they're very highly interactive. They require a lot of face-to-face interactions at the manufacturing site. Well, the employee involved suffered from IBS, and she had requested on multiple occasions and was allowed on multiple occasions to work from home, because Ford did have this telecommuting policy, and she wanted to work 4 days from home. And the policy did, in fact, allow for that. However, each time she asserted that she needed this accommodation and Ford tried it, it was very unsuccessful in that the employee was not productive, she was not meeting the goals and objectives, and it turned into be not very successful. And so they called her back in each and every time. She went back for a fourth request, I believe it was, to once again seek that telecommuting accommodation. And Ford said, no, we're not going to do this. And then she was subsequently terminated because of performance issues, and a lot of that stemmed from the fact that she wasn't meeting those job expectations. The case went, it was decided, and then it went up to the Sixth Circuit, and then the Sixth Circuit originally held that a 4-day-a-week telecommuting arrangement could be reasonable for a disabled person, and that based upon the modern state of technology, they thought this would be appropriate, and they really should have, looked at this for the individual, in essence, saying that the employee was entitled to this. Well, the employer, Ford, appealed this and asked for a full panel review, and when they had the full panel review, the en banc, At that point, it was overturned by all of the judges on the Sixth Circuit. And at that point, the Sixth Circuit took it all the way back to the beginning, never got to the position of whether it was a reasonable accommodation to let her telecommute. And instead, they focused on and really relied on a lot of common sense, and that's what they referred to it, about what does the job require, is the attendance, is the predictability important? And so they looked at all of these common sense factors to find that she was not even qualified for the position. We never even got to the point of accommodating because of her inability to be at work and to meet those essential functions of the job. So contrary to what the EEOC is saying, that attendance is not maybe necessary, what this court pointed out and what Ford had in its job description for her was it was interactive. It did require that face-to-face interaction, and so therefore attendance was part of the job description. And so I think this was a good decision because the previous decision took away from the employers the ability to say this is not working for us, this is not a reasonable accommodation, and then with this en banc decision, when they came back and reversed that, they put it back on the employer to say, Mr. Employer, you know what's best, let's look at it in terms of what's required for this job, and also don't lose sight of common sense. So I think this was a good decision coming out of the Sixth Circuit that allows the employers to make the types of decisions about reasonable accommodation that the court previously was taking away, or seemed to be taking some of that discretion away from them by the decision. Another big issue that comes up when you've got individuals out on ADA and FMLA is what benefits are they entitled to? How do we deal with this? Specifically under the ADA, there's nothing that says that we have to provide them the benefits. However, you know, we need to make sure that we're giving the same benefits to those other individuals that are not on ADA leaves and things of that nature. So it's always recommended to carry those benefits, especially if you've got a defined time that you know the individual is going to be out. The same thing with FMLA. By regulation, we're required to continue it at the same level as prior to the leave. And they normally, the other benefits like vacation, things of that nature, they're going to be controlled by your policy. And most policies say that you don't accrue those types of benefits if you're not actively working. They rely upon an FLSA standard in making that determination. But there again, that's going to go back to what your policy is saying when you get to some of those other components of the benefit. The main thing to do is keep in mind you should treat everyone the same across the board when you're looking at, you know, what benefits are available and what you're granting. I know a big issue that comes up during the course of FMLA leave and also can on ADA as well is the payment of some of those benefits where the employee is responsible for a portion of maybe their health care and that sort of thing. And that's a very hard call for an employer to make as to how are we going to deal with this. Are we going to stop these benefits while they're on FMLA? And I usually recommend not doing that. I would say see what type of plan you can put in place to recoup some of those monies as they return back to work and make sure you're compliant with your state laws on doing that. But there again, that's going to be a decision that's going to be made company-wide and across the board. The other question that comes up when we've got these leaves, what about reinstatement? Do we have to give reinstatement? Under the FMLA, you bet. If they're coming back timely, then you need to reinstate them to the same position that they were in. They need to be paid the same. It needs to be like in the same. ADA is a little bit different. If we can keep them in the same position, that would be great. However, if you've exhausted your FMLA and now you're on a pure ADA leave, then we can fill the position or we might slide somebody else in it temporarily. But we need to see if we can return them back to work in something same or similar. However, we don't have the statutory obligation like we do under the FMLA to hold them to that same or substantial equivalent position under the ADA as we do the FMLA. And so generally, if you've got your business needs demand, after your FMLA is exhausted, they're moving into ADA, you can shift your personnel around and then bring the employee back. It may not be the same, but you can certainly do that. What medical documentation is required for the different types? Under the FMLA, you're going to rely on the certification process. Although you don't have to use the DOL forms, I recommend that you use those forms just because they're compliant with the DOL. I also like to make sure that I've got somewhere on my forms a GINA statement that I don't want any of that information. I only want what is necessary for the FMLA. And the ADA, you're going to get probably more medical information than you would on an FMLA, only because you're probably engaging in that interactive process. You're asking them what type of accommodation they're seeking. Then you're getting that medical information from the doctor as to what is impaired, what's substantially limited, what are you recommending that we do, and from that you're going to have a little bit more medical information from the doctor. I would always recommend that your ADA information and your FMLA information is never kept in the employee file. It needs to be segregated out into a healthcare file, and that's the type of information that you're going to be keeping separate and apart from your regular employee information. Now, under the ADA, you're going to have a number of different avenues to request that additional information as to what's going on, what type of information, and all of that may require a medical release from the employee so that you can get that information from the doctor so that they can speak freely to give you the information so that you can then engage in a dialogue of how we're going to accommodate this. And this is where the FMLA and the ADA differ somewhat, probably greatly, if you're really accurate about it, because the FMLA, we get the certification back, we're going to look. We're going to see if all the boxes are checked. We're going to see if everything is compliant. What are they looking for? Then we're going to either approve it, we're going to need more information or whatever, and then we're pretty much done with the process. With ADA, it's a little bit different in that you're going to have a dialogue with this individual. And importantly, you need to document all of your dialogues because that's the focus that the EEOC has. And in looking at the statistics of the charges that are going up, retaliation exceeded rates for the first time. Well, it did it for 3 years in a row. And number 3 on that list of charges is ADA. So these issues are not going away. They're only going to increase. An interactive process is one of those that is the focus of a lot of the litigation, and you've got to be able to document that you've had it. When they first ask for that accommodation, document it. When you get your medical information back, talk with the manager, see what we can do to accommodate. Then have a conversation with that employee to say, this is the accommodation that we can offer you. Just because the employee says, this is the accommodation I want, does not mean that that's the accommodation that we have to give to the employee. We look to see how we can accommodate this, what fits within our business scope so that we can do this and not cause that undue hardship. But you have to have that dialogue, and always make a note or recommend that after you do make this accommodation, I would calendar it to go back and review the accommodation, make sure that you still need it, has anything changed, just to go back and ensure that, we're complying with what we need to do as far as that interactive process. And there has been litigation wherein the employer has not engaged in the interactive process, and the courts have commented on that and found that it was improper and that they should have engaged in that dialogue. So it's very important that you do it and that you document it so that you can go back and reflect the history of how we got here on the accommodation.
Now, of course, as Robbin recommended, to use the DOL form when it comes to certification. So when does the certification process take place? So if an employee comes and is asking for leave, the employer should provide the certification form just immediately at that time, but it should be provided to the employee. Let's say it's not provided at that time. It should be provided at least within 5 days. Now, once you give the certification form to an employee, they have 15 days to return that form back completed. So let's say, for example, that the certification form for the FMLA leave comes back, it's vague, ambiguous, or non-responsive. When that happens, you should contact the employee and point out the defect, what's wrong with it, what additional information is required, and then the employee is required by the regulations to return a completed certification back to you within 7 days. So once obviously, once the employee provides a complete and sufficient certification, that's when FMLA is triggered and you're obligated to provide that leave.
And make sure that when you have agreed, or if they've met the qualifications, it is sufficient, make sure you give that designation in writing that they've been approved for the FMLA, and that designation should also then incorporate whether there's going to be any return to duty or anything like that.
Now, the regulations also provide specific requirements, and the serious health condition is really where you have the most FMLA leave. So when you receive a certification for a serious health condition, the certification should provide the healthcare provider's name, the address, the phone number, the type of medical practice it is, the fax number, and specialty. Obviously, they'll also include appropriate medical facts. And the one thing you'll see is sometimes the diagnosis will be listed, but it's not required. So one thing you will need to see, obviously, though, is there'll have to be sufficient information to show that the employee can't perform their job at that time for them to qualify. And so when we talk about consequences or responsibility, it's really the employee's responsibility to provide the certification that includes all of the necessary information. This obligation is not on the employer, although you do have to point out where there is a defect and where additional information is needed. That being the case, this burden does rest with the employee.
And a lot of employers sometimes will take over the burden and, try to get the doctors to send it back. Just keep in mind, you guys have enough to do without taking on that. It falls back to the employee. Then we hear a lot of, well, the doctor's charging me for this. The doctor won't fill it out. Those are issues the employee needs to address that the employer does not need to address. The only time I've seen it be successful with an employer was where it was a very large employer in a smaller area, and they could actually go to the insurance company and say, these doctors are not cooperating, and they could put the pressure on, but that is very rare. So at the end of the day, let the employees get this thing completed and get it back to you so that you can make the determinations that you need to make. And the same thing is true under the ADA. As I had mentioned, none of this should be kept in the employee file, and it needs to definitely be separated out. It can create an issue if the EEOC comes on site for any type of investigation and they ask to look at your files and they find that. That's a violation. Also, I recommend keeping these where it's a need to know, meaning only those individuals that should be aware of this condition should have access to that information. They should always be locked and kept and maintained by HR during the course of that. And, the documentation is going to vary. As I had talked about earlier, you may have that request for accommodation that comes in. Then you may have that documentation that's going back to the doctor to say, tell us what is going on and what can she do. And I'm going to loop this back to job descriptions again. I mean, these are essential when you're dealing with FMLA and ADA issues to send it to the doctor so that they know what the employee is doing. Because a lot of times the employees don't give full and complete information. And if it's something that is hyper-technical, or if it's something you don't think the doctor's familiar with, I've even seen the picture job descriptions that are very helpful so that the doctors are in fact aware of what these employees are doing so that they can give an accurate response to what they can and can't do. And there was a question that came in regarding job descriptions that I'm going to go ahead and address. And the question was, should we include regular and predictable on-site attendance in some job descriptions? And I would definitely say yes, you should do that. And the reason for that is, especially if they're in those positions where their attendance is essential, that you have to have them there, that something is not going to work if that employee is not there. You definitely need to spell that out. And it may be a situation where you've got coverage that doesn't require that everyday attendance. And so I would delineate those that are more important than others and definitely include that in, especially if you're going to rely upon that if you're making some type of employment decision based upon that. And there again, when we go back to talking about those return to work certifications, you should have something when you designate the FMLA. You should be telling that employee that you are going to have a return to work and we're going to need this. Keep in mind, this is only for their own serious health condition. We also can't require that on any type of intermittent leave. It's only going to be applicable for the serious health condition for the continuous time period, and they need to be put on notice that they're going to have to provide that type of information. The same thing is going to be true with your ADA. Someone's been out on that reasonable accommodation for a period of time. We want to return to, we want to know whether they can come back and perform the essential functions of the job. And this is especially true if they've been off for any period of time, and we want to make sure that we make them aware of that. And a lot of times what I suggest you do is much like the FMLA. When you're going through, you're giving that reasonable accommodation of time off, then you tell them at the time that they're going to return to work that they're going to have to present that note from the doctor giving them the release so that they can come back. And as I stated, you can't require it if they're on intermittent leave, and you have to make sure that you're doing this uniform across the board. You can't single out anyone because you know that Bob may be a problem child and you really want him to bring that in, and you don't care about anybody else bringing the return to work. So it needs to be uniform. Now, that doesn't mean that, you know, we have to do it across the board for every employee. Now, you can break it down into the different job departments and things of that nature. If you've got a clerical worker or a large clerical staff that you think you really don't need a return to work on them, then you could certainly carve those individuals out. But by far, it's much easier just to be very inclusive and say everyone has got to have a return to work after they've been out. Notice is another thing that's required. We have to make sure that it's in an accessible format to all applicants' employees that describes the ADA provisions. Most of the time, this is included in your policies. It's also included in your EEO. It may just be a real quick blurb saying that, you know, we've got this disability, we recognize this, and that is sufficient to be able to comply with giving the notice under the ADA. Another issue is on FMLA, of course, we've got to give notice. You need to have your policy in the handbook. You also, I always recommend that when they're asking for the leave that you give them that notice of eligibility. Then you've got to do that written notice of designation. If you fail to do that, then you could possibly lose the ability to count that time. And there's some situations where you can do it anyway, but generally that's rare, and it has to be in a situation where they're not going to have any adverse consequences for them. And then you also need to give them notice of what they're going to have to do as far as getting the certifications back to you within that 15, and also the fitness for duty to return back to work. We've had another question, and the question is the employer obligated to consider or offer ADA if the employee exceeds the 12 weeks of FMLA? And that is possible. After their FMLA is exhausted, you're going to have to look to see what's going on with that condition, to see if it's something that you think might be ADA compliant. And if it is, then you may have to say, we can do this, and go through that interactive process. And I would always recommend it, especially if it's something you believe that falls within those categories, which most everything is, because you don't want a situation of, well, your FMLA is exhausted, you didn't come back, and now we're terming you. Now, if it's their own serious health condition, you know what's going on, you think it's going to qualify under the ADA, then I would immediately move into that interactive process to see, do you just need more time off? How much more time off? If they give you that indefinite response, that's the beauty. Then you're done. But if they say, oh, I only need 5 more days, then always giving that type of time off is always reasonable. And so I would always say, yes, you need to look at it and think of it in that context.
I think that's also an area where the lines kind of get blurred, because it is the obligation and the burden is on the employee to request an accommodation under the ADA. Employers, generally speaking, don't have any obligation to go seek the employee out to say, what accommodation do you need? In fact, you shouldn't ever just assume that an employee has a disability and needs an accommodation. But in that situation, the employer is on notice that the individual is missing work because of a serious health condition. And so whether or not extending leave beyond that 1 year is reasonable will depend on the ADA. And so you do probably need to engage in the interactive process there rather than just immediately terminating the employee right at the 1 year mark. Do you agree with that, Robbin?
Exactly, and that goes back to also the information that they're required to submit to you. And just like under the FMLA, they've got 15 days to to bring that certification back to you. You may not terminate on day 16. You may then do a follow-up and say, look, we didn't get this. We're going to have to deny or delay. If we don't get this back, we're going to give you an additional X number of days. The same thing is true with the ADA. If we're talking to an individual to look at some type of reasonable accommodation, we tell that employee what we need, what they need to do. We're engaging in this dialogue, and the employee does nothing. Then, we follow back up and say, Mr. Employee, you didn't get this information back to me. We need this so that we can make a determination on your accommodation. And then if they still do nothing, then at that point, we've exceeded what we needed to do. We gave them the chance, we followed back up, and then we don't have to provide that accommodation at that point in time because they did not get that information back to us. But we have to make sure that we're doing it reasonably, as far as we can't say you got 2 days to get this back to us. We have to give, a reasonable amount of time and define it as to when they need to have it back. And I always recommend that after, and it's a very conservative approach, after I've given them 15 days to get that certification back, I always say, you really need to give them another 5. And then if they don't get it back in at that point in time, then you can call it. I do the same thing on ADA. I give them X amount of time to get it back. If they don't, then I add additional time to that. The main thing when you do that is define that time period and make it something that's going to be institutional to your department. You're going to do this each and every time. And that way, if anyone questions your process, you can say, this is what we do, this is how much time, this is how much additional time. And you can always provide that information should you have to. And I think it's very important to do that. And then I think Frank's already addressed some of the obligations when they come in and request it. The same thing on FMLA. Employers have to be somewhat proactive. You need to make sure your supervisors are trained. When you've got an employee that's been out for multiple days, we need to make some type of inquiry. Hey, do they need FMLA? Do we need to send this? And do that. If it's something that they're planning a surgery, then they need to give us the 30 days. And especially if it's something, say they need foot surgery, they know they're going to have this in, 30 days. They don't give us notice until the last minute. Can we delay that? Yes, we can, especially if it's something they've known about. But I would, I'd be very cautious in how I applied that and make sure that I was consistently doing that as well. And I'm going to wind this down kind of quickly. We're running out of time. But what we've got on these last is just some tips for effectively managing the leave. And the main thing is with your FMLA, enforce your call-in procedures. Make sure your managers know what they're looking for. Make sure they're trained. Give all the notices. Make sure that the individuals know those expectations and they know how to follow through on that. I can't say enough. I'm a huge believer in the certification, making sure that it is complete the way it needs to be, especially on frequency and duration. You can't control it if you don't know how long it is. And also monitor it. You can do that. And then, utilize that second opinion because that can come in handy. I wouldn't say do it every time, but, in some situations you may just think that's the best way to deal with it. Let's use that second opinion. But I would make sure that they're adhering to the call-in procedures. And the other thing that I'm a big believer in is job descriptions, that you've got to have all of that in there so that you can use it even on your FMLA forms for return to work and also with your ADA. And it's also a great tool to use in hiring too, because then you can say, can you perform these essential functions of the job? And then you've got that, commitment at the beginning. And the other thing to take away on this is the interactive process. I can't stress the importance of making sure that you've got something documented on that interactive process for ADA issues, so that in the event that it comes back that there's, questions or you end up with an EEOC charge or litigation, then you can go back and say, this is what I did and when we did it and who was present and what we discussed. But these are just some tips. I kind of ran through these really fast. We're going to open it up for some questions. If you've got questions, please feel free to send those in, and we're going to try to answer these best we can. All right, we have a high-risk pregnancy, definitely FMLA eligible. But when does the clock start? Routine visits or only if complications occur? Generally what I would do is I would start the clock on even some of the routine visits if they're going to be away from the office on the intermittent. Now you have to let them take the smallest increments of time that they want to take on doing that, and that may be 30 minutes on, once a week or 30 minutes once a month as far as needing to go to the doctor or those sorts of things.
And the second question included in the same one is intermittent FMLA, rolling calendar. It never quite uses the full 12 weeks. Is the renewal date 1 year from the date FMLA was initiated?
Well, in the rolling calendar, that's exactly true. And that's a hard one to manage because as it's rolling, you're still accruing the time. I think those are all the questions that we've received at this point. If anyone has any other questions, we'll be glad to try to take those.
Okay, there is another one. If the employee is telling coworkers about their serious health condition, how can you stop that and keep things more confidential?
That's a good question. And generally, you can't stop the coworkers from talking about it. You just have to make sure that you're not sharing that information with them. And you might caution that employee and say, we keep this information confidential so that we're not sharing your medical or anything dealing with your health condition with any other employees, just to kind of let them know that it's not coming from, it's not coming from HR, it's not coming from management, because we certainly can't disclose that. That also raises another point, which often becomes an issue, is when you grant that ADA accommodation. You can't share that information with any of the other employees that Bob's got an accommodation. And if you have to share it with the supervisor, you can, but it still can't be disclosed to the others. And when you hear those complaints about Bob being able to take a little bit longer break, or he doesn't get there always on time, we can't say it's because he has an ADA accommodation. We just have to say we treat everyone the same and move on to keep those protections in place.
So the next question is, what about FMLA working concurrently with leave due to workers' compensation? That's actually a great question, because if you have a work-related injury, the person might be off of work for workers' comp and being accommodated because it's a workers' compensation injury while they're being treated, but that person could still also qualify for FMLA leave at the same time, so the two can run concurrently.
And it's going to be controlled by your policy, and I'm a big believer in running everything concurrent. If they've got vacation, they got sick leave, make them take everything concurrent with their FMLA. And the reason for that is, and some employers don't, and I guess I'm very cynical in this, is you want to get through that FMLA. Your FMLA time is protected time. And if you have those, and it's only for those that are abusing it, that you want to exhaust that time so they may not have those protections there. And so you can define what's going to run concurrent with your FMLA, and you can certainly run your workers' comp, short-term disability, anything that you need to run concurrent, you can. You do it by policy.
Okay.
I would not recommend that. I'm sorry, I should read the question first. Can a company put a person who is on FMLA on COBRA in order to charge for the benefits? I would say no, not while they're on the FMLA, because they're entitled to those benefits. And what you can do is, if they're not getting the pay for those benefits into you to make those payments, then you can terminate the benefits because they're not paying, they're required to pay. But I caution you in doing that, because that can run afoul, especially if it's their own serious health condition. They've got medical issues, and then you're cutting off their benefits. But we have to leave them on the benefit program while they're on FMLA. Then when they get to the point of non-payment, then that's a harder question.
Okay, looks like pregnancy after 4 months of employment turns into high risk with indefinite leave. Under, let's see.
Yes, under 50 employees, so you don't have any FMLA. The employee is going to be out of work for approximately 6 months. Do we have to hold this job? And so I'm not sure if the 6 months is going to be from the 4 months or if it's going to be after the end of the pregnancy. What I would recommend on this, because the individual does not have any FMLA, I would look to see what kind of personal leave you have. What's in your policy about personal leave? I would probably provide some type of unpaid leave to protect it. I don't know that I would hold the job for that length of period of time, especially if it was a crucial position that you needed to fill. What you could always do if you had to fill the position is say you're eligible for reemployment. I would hold it as long as I possibly could to see. And then if you can't, because it's crucial, you need to, then I would tell her she could reapply at that point in time. The Young case has put all employers in a position now of looking to see if we can accommodate under the pregnancy. And so you just have to look at the time period. And by virtue of giving a 6-month return, that puts you in a really hard spot. Is that something we can do? And it may not be something that's possible for that employer. Looking at another question, we have an employee who has FMLA leave to care for his wife. He continually calls in because his wife is ill. Is there anything we can do to require the employee to prove his wife is ill? This has been going on for over a year, and he seems to keep just under the 12 weeks. That is your classic sign of FMLA abuse. And what I would do is look to see if he's meeting or exceeding that scope and duration of the need to care for his wife. And if he is, then I would definitely recommend you restart it, because you could definitely do it in that situation.
Okay, I think we've run out of time. I know there's probably more questions, but if you have additional questions, you can direct those to us or to Eric, and we'll be happy to help you. But thank you for your time today. We hope you found this helpful.
Yeah, thanks, Robbin and Frank, for coming on. Thanks for the presentation. Thanks, everybody, for your questions. There's Robbin's and Frank's emails. If you would like to write them down and email them any further questions. If you're here for SHRM and HRCI credit, the codes are on the screen. We're also running a special offer, since we have 2 publications authored by FordHarrison, one by Frank today, today's speaker, and the other by Nancy Holt in Washington, D.C. That's the ADA and FMLA guide and hiring, firing, and discipline for employers. Frank, Robbin, do you have any final words before we sign off?
I think I would say, thank you very much. We enjoyed presenting today, and I think, if you have any questions, please reach out to us. We'll be happy to respond to you and give you the best answer we can. And anyway, thanks. Hopefully we're helpful today.
All right. Well, thanks again for coming on. I encourage everyone to reach out with further questions to our speakers. They did a great job today. On behalf of HRsimple.com and FordHarrison, thanks for spending time with us today, and have a great Easter.